Welcome to Networking Arizona with host Carol Blonder. You'll hear interviews with businesses located throughout the valley. Networking, it makes a difference.
If I traded it all.
Well, welcome back. Now, my next guest is Ryan Borges, and he is with Guy Brown Attorneys. Welcome to the show. You've been on before, and we did, at that time, we were talking DUI, but now we're talking a little something else. Tell us a little bit about Guy Brown and the firm.
Well, thank you, Carol. We do both criminal defense and family law. So we handle major felony cases ranging anywhere from, from homicides to armed robberies to aggravated assaults, as well as misdemeanor cases like DUIs or shopliftings. But we also do family law, which many people may not know. And that includes divorces or modifications of custody or child support, adoptions, things like that.
Now, I'm going to go right in right now and just start talking, because everybody knows that everybody waited till after the holidays, right, to get a divorce or to do anything, to at least say anything.
That's pretty common. You know, they don't want to start that process during the holiday time, so a lot of people wait till that's over, and then in January, February, usually you kind of get, an increase in the amount of petitions that are filed with the court.
Right. Now, okay, so what do people need to know if they're considering then filing for an Arizona divorce?
Well, the first thing I try to tell people is that Arizona is a community property state. So there's 9 community property states in the country, Arizona is being one of them. And what that means is that all property that is accrued during the course of the marriage or any debts incurred during the course of the marriage is going to be considered community property or community debt, which basically means each party jointly holds that. So they're entitled to their equitable share of the property or debt. There is some exceptions, one of them being a gift or inheritance. So if your parents die, they leave you an inheritance of, let's just say, $50,000. That's going to be considered your separate property unless you change it to community property, which basically means, like, if I commingle it with our joint bank account with me and my wife, well, now it went from being separate property to now being community property. But generally speaking, that's how community property law works. The other thing they need to know, there is a residency requirement. In order to file for a divorce in Arizona, at least one of the parties needs to have resided in Arizona for at least 90 days, or Arizona's just not going to have jurisdiction. The other thing is, they do have minor children, they're going to have to start thinking about what they're going to do as far as parenting plan and splitting up the custody.
Right. Do you do consultations with people?
We do. They can certainly call the office, and we'll set up a free initial consultation with them.
Okay, so they do free initial consultations. The number is 602-396-7100. And when they call in, what can they expect? Because sometimes people who have put it off, and now that they're ready to pull the trigger, so to say, how long does it take to get an Arizona divorce?
There's really no timetable.
Is there a waiting period?
Well, there's a cooling off period. Even if you file for a divorce, if the very next day you reach agreements on every issue and you're like, I'm ready for this to be over with, the court, you could submit all that paperwork to the court. The court's not going to sign off on it until the 61st day. So there's that, what they call the 60-day cooling off period. So that is probably the absolute minimum. But generally speaking, it really is going to depend on if there are agreements. Are we fighting over every little thing? How much is out in the community that needs to be looked at as far as, from an attorney perspective, how much discovery do we need? How much information do we need? Are there bank accounts? Are there retirement accounts? Are there 401ks? Are there other investments in stocks and things like that we need to know? We have to have all that information.
All that money they're hiding.
It's all out there. And the more of that there is, potentially the longer it can take. And the other thing really is, most of the cases that take a longer period of time, whether it's 6 months or a year or sometimes longer, it usually is involving custody or child support or parenting time. Usually that's going to be the big issue that drags a case on.
Okay, so in the courts, in the Arizona courts, do they usually side with the mother? That's what people think. Especially in custody cases.
It is, but it's absolutely not true in Arizona. Legislator actually changed the law back in 2013. Starting January 1st, 2013, the law changed. The term custody is really not used anymore. It's called legal decision-making now. And it's no physical custody, and there's parenting time. So, and what the law did was, specifically, it actually encourages joint legal decision-making and trying to maximize the amount of parenting time that each parent has with the child or children. And it also actually specifically forbids the court from giving any kind of preference to one parent or the other based on either the parent or the child's gender. So simply the fact that because mom is mom, she's going to have custody of the kids, and dad's going to get every other weekend, which is
sometimes
pretty
dads
typical.
Don't want custody of the kids.
Sometimes.
Mine did it.
But I mean, that perception is absolutely not true.
Okay. Now, they call you, they're going to give free consultation. What is the difference between coming to an attorney and having an attorney do it? Because a lot of people now, especially when they see these ads on television, that they can, they can go and they can fill out all the documents and file them. What's the difference between coming to an attorney, and do they need it regardless whether there's money or not?
My recommendation is to always have an attorney in these type of cases. Now, family law is a little bit different than criminal law. Okay, if you're charged with a felony offense, you're going to have an attorney, whether you hire one or the court appoints you an attorney. But that's not the case in family law cases. If you're going through a divorce, you may not have an attorney. It's possible that both sides may not be represented. It's possible one side may have an attorney, but the other party does not. I'm
going to tell you right now, if your ex-husband or your wife says to you, you don't need an attorney, trust me.
Yeah.
If you don't need an attorney, you can get a paralegal or whatever I did wrong, which is what I did. And I'll tell you, worst mistake, and I'm saying it that way because it hurts you in the end, because they're not looking out for me the same way.
They're not. I mean, lawyers are legally trained. They handle these cases every day. They know what they're doing. And even if the other side has an attorney and you don't, you're at a disadvantage because you don't know all the laws. But the court, if you're in a hearing, you're in trial, the court's going to hold you to the same standards. And if you don't know what you're doing in there, you easily could get essentially.
Well, it comes out in the long run. Okay, and I'll tell you how, because we can go over all of this. We're going to get to most of them here. And I'm just going to talk to you because I've obviously been through one. But also what happens is at the end, when it's the afterwards, after you have even got, you've filed for divorce, you're divorced, now all of a sudden there's trouble because the kids turn 18, and there's things that you could have written in there that could have protected you to maybe getting this or that. But if you don't have someone that's protecting you, then they're not going to have that in there. And then what happens? You are whatever.
Right. I mean, it's if you do reach an agreement, you're ultimately going to sign a consent decree as well as a parenting plan with the court, and it's going to get filed, and that's going to be valid. And so if you sign off on it, and you sign off that, hey, husband gets to keep his entire 401k, and it had $100,000 in there, and well, that's $50,000 that you may have just lost out on because you didn't know what you were doing. So it really helps you to contact an attorney, talk to someone, and really retain someone to try to protect what essentially is going to be yours.
Right, and don't listen when they say it'll be okay. They would never hurt you. That's not true. And I'm just saying, give them a call. The number is area code 602, write it down, 602-396-7100. They do free consultations. And do they have a website as well?
They do. It's www.azlawguy.com.
Okay, and we're going to go to a break. And when we come back, we're going to talk further about, of course, joint and legal decisions and custody and all of that. And we're going to come back, and when you come back, you're going to talk about all these other things. Write the number down. It's important because I know a lot of people have been thinking about this, and now you're ready to pull the trigger. The number is 602-396-7100.
If I traded it all
Here we go. So welcome back, everyone. We are talking with Ryan Borges, and he is with Guy Brown, attorney. You know, we were talking at the break a little bit that if the office that you both do, both criminal and family law, and it's good because you know what? A lot of times, especially during the holidays when they've been drinking, they've been fighting. So, and nowadays, if you get in a fight and if you touch somebody even a little bit, you're going to jail, right? So that's criminal, and then you're getting a divorce because the person touched you and you're mad at them, and then now you're up for a divorce, right?
Yeah, you know, it helps to be able to do both areas because oftentimes criminal cases, especially in domestic violence cases like you're talking about, ultimately lead to, if it's not a dissolution, it's something else family law related, and I'm able to either advise them or potentially represent them if they end up going down that route.
Now, again, I implore everybody who is thinking about this, and especially the women out there, that when I didn't know, I listened, and I got hurt by it. I got burned. So the number to call is, write it down, 602-396-7100. They do free consultations. The website is azlawguy.com. Okay, so what's the difference between sole and joint legal decision-making?
Well, basically, legal decision-making involves the important decisions regarding a child's life, which is going to be health, education, and religion. So if you have joint legal decision-making, it basically means both parents need to discuss and come to an agreement on those types of decisions, whether what doctor the child goes to, what school the child goes to, if they're going to be brought up in a certain religion. They need to make those decisions together, okay? If you have sole legal decision-making, that basically means one parent can make those decisions on their own without really consulting the other parent. So that they can still certainly consult the other parent if they choose to do so, but they aren't going to be required to.
To me, that's simple. To me, asking where they need to go to a doctor or what have you, what I think is what comes up in this decision-making, and I want to know what happens with that, is when let's say your child is not doing well in school, maybe doing drugs, whatever. What about those decision makings?
Well, even if one parent has sole legal decision making, the other parent is not completely shut out. So that parent is still going to have access to medical records, access to school records, parent-teacher conferences, those type of things. So it's not like, geez, I never know what's going on with my child because my spouse has sole legal decision-making. I don't even know how he's doing in school. I don't know what's going on with his doctor, if he's healthy or has some problem that needs to be addressed. They'll be able to access that stuff because they're still the parent, okay? So, if you have an issue like, hey, my kid's not doing very well in school, the other parent should still know about that as long as they are an active parent, of course.
Mm-hmm. Right. That's what it's all about, being an active parent. But also, and do you do mediation at all? Or does that come about at all within your legal firm?
It doesn't really happen within the firm per se. Mediation does happen within the context of family law cases, though. Oftentimes, the court will send the parties to mediation to see if they can reach an agreement on their own without having to, continue to use more court time and expenses with having to litigate it. There's also other avenues outside of mediation. We can request what we call a settlement conference where the parties will go and meet with a judge pro tem and present the issues to the judge pro tem and try to see if we can facilitate and hash some things out.
My favorite part to talk about, the alimony. The alimony that we're not getting.
Yes, spousal maintenance. Mm-hmm. Yes.
So let's talk a little bit about that. Will one party have to pay alimony to the other for sure, or how does that work?
So alimony is called spousal maintenance in Arizona, and it's not automatic. That's a common misconception is that, hey, if there's going to be a divorce here, one parent or one spouse is going to get spousal maintenance or alimony out of it.
And how much alimony is also what people don't realize sometimes.
True, because really it's a two-step analysis for the court. The first step is the person has to qualify. The court has to establish that there is a need for it. Okay. Once they meet requirement A, the court then will go into the analysis in part B, which then is how much and for how long. It's the one area of family law that there aren't any guidelines really, like child support, there are specific guidelines for child support calculations. And once we know the gross monthly income for the parties, we know how much parenting time each parent's getting, we know who's paying for medical insurance and other expenses. You're going to plug all these numbers in, and it's going to spit out a number, and you're going to say, well, child support is this amount per month. That doesn't exist for spousal maintenance. So you could have the exact same situation with two parties, and I can go into 3 separate courtrooms and say, okay, Your Honor, here are the facts of the situation. Are you going to award spousal maintenance? If so, how much and how long? And I can almost guarantee you that I'll get 3 different numbers and probably 3 different lengths for how long the spousal maintenance is going to be.
How about when it's non-modifiable? What happens then?
Well, yeah, I mean,
what happens when they don't? When they've signed that, they've signed it years ago because whatever, and then something changes because circumstances change, but it says non-modifiable.
Yeah, it's going to be very difficult if you sign off on something that's non-modifiable to then go down the road and say we want it changed and modified, basically.
Because you have to modify everything?
Well, you don't have to modify it, but
you have to go to court?
But generally speaking, even like child support is also modifiable.
Right.
And that's, if you have a parent whose income dramatically changes and they say, hey, I can't keep paying $500 every month. My income, I got let go and my income is now half of what it used to be. You have to file a petition to modify with the court to change that amount, which is why you don't, unless you're the party receiving spousal maintenance, and maybe a non-modifiable agreement is great for you. But if you're the party giving what they call the obligor, who's paying spousal maintenance, a non-modifiable agreement really may not be the best thing for you if your income substantially changes. You're not going to be able to change it. Now, the flip side of that is, well, the other party's not going to come back down the road and say, well, I want to modify it and I want to go up now. So there is that benefit as well. It's going to stay one fixed number for a certain amount of time, but if you sign off on non-modifiable spousal maintenance order, it's basically going to stay that way until it's over.
Yeah. Now, again, their information is area code 602-396-7100. They do free consultation, initial consultations. The website is azlawguy.com. What are some of the other important things that people should think about when they're doing, thinking about getting a divorce? What kinds of things should they be prepared for when they call you?
Well, the first thing is ultimately they're going to have to. I always tell clients that they're going to have to do a little bit of homework for me. They're not just going. You can't just come in, retain me, and say, "Okay,
what is
take
it?
over
What's
and
the homework?
Go get me divorced." The homework is going to be there's mandatory disclosures in family law cases, okay, and pursuant to Rule 49 of the Arizona.
Is that
rules.
new?
No, it's been around.
Okay, so go ahead.
So the rules of family law procedure dictate that the parties have to disclose certain information
to
each other.
tax information. Okay.
That includes income tax information, your income, investment information, bank account information. I tell clients they need to put together all this information for me, and oftentimes I'll give them a copy of the rule and say just use this as a guideline because it basically tells you what you need to provide to the other side, and put that together for me. Because we're going to have to disclose it anyway. The rules tell us we have to. So that's really the first thing I tell them is you got to work on this. And sometimes it takes a little bit of time, but you have to work on it and get it to me. The second thing is if people have children, I really try to tell them that if there's any bitterness or animosity between the parents because they're getting divorced. Not all the time. I mean, usually most of the time there's some, but sometimes it's fairly amicable. But
it is until they have to pay money. Until they have to they're paying the alimony or they're paying the child support, and somehow.
But ultimately, that if the bickering or yelling at each other is going to rub off on your kids, the kids are going to notice that, and it's not going to be healthy for them. So I try to tell them, look, during the course of this proceeding, you have to be civil with one another. You have to think about your kids first.
So sometimes is it best to get a legal separation?
Well, the legal separation is really not that much different than a dissolution. I mean, it essentially kind of does the same thing. A lot of people just do the legal separation versus a dissolution, mostly for religious reasons, at least in my experience. But if you go through a legal separation, you're basically doing the same thing you're doing in dissolution. You're still going to be dividing up assets, and you're
Just
still going to be dividing up
cost you twice
debts.
as much money if you do that.
The other thing that people should know is that the community keeps on running until the other party is served with a petition or accepts service. So if you have a spouse that you think maybe has a problem, whether it's a gambling problem, alcohol problem, or some issue, or is out just spending, that's all technically, I mean, you may be able to claim some of these things as community waste as far as gambling is concerned, but if they're all just buying stuff, that's, and putting on a credit card, that's all going to be community debt. When they were served, that's going to stop that. So then if they go out the next day and buy a brand new car, well, that's your car and your debt now. So,
you guys, there's always a really good reason to call an attorney. Give them a call, 602-396-7100. It's azlawguy.com.